another Rule 23 decision, and we've been talking about those cases a lot lately. This case is called Benson, and it has to do with, as you can tell from the title of the program, jumping off of the dock. So why are we talking about another Rule 23? We're talking about it because it's an interesting case. It presents a lot of the issues that we've been talking about here. So I just wanted to briefly talk about that. And before I get into the program, I got a letter from the chairman, from Chairman Brennan, yesterday that asked me to make a special announcement about an issue that has come up. So I'm just going to briefly read the chairman's letter to Whitlam. On July 24, 2019, I gave the following instruction to the IWCC's arbitrators and commissioners. Effective immediately, you must instruct the parties before you that they have an obligation to comply with Supreme Court Rule 138, personal privacy information mandates. You must require that, in addition to the traditional admissibility issues such as foundation, authenticity, hearsay, etc., the mandate of Rule 138 is also met as a predicate to admission into the record before you. Based upon the requirements of Supreme Court Rule 138, documents containing such information are inadmissible and will not be accepted. Under Rule 138, the following information may not be included in documents or exhibits filed with the court: Social Security and individual taxpayer identification numbers. Number 2, driver's license numbers. Number 3, financial account numbers. And number 4, debit and credit card numbers. So the chairman asks that to aid in dissemination of this information to the workers' compensation bar, the commission has prepared the attached document. So you all should have received this document from the chairman's office that was available. It's a double page, one-pager about Rule 138. I trust you will share this information with the members of WCLA at tomorrow's Brown Bag Lunch at the Thompson Center, and you should all by now have a copy of that memo from the chairman's office. So the way I understand that this issue came up was that a review was filed in the Lake County Circuit Court of a commission decision, and when the record was tendered to the circuit court from the commission, the circuit court judge in Lake County discovered that in some of the medical records, which were put in as exhibits, that the petitioner's Social Security number was on the medical records. And therefore, the circuit court judge rejected the filing of the commission record, right, because it was in violation of Rule 138. So that's kind of the genesis of this problem. The circuit court, at least in one instance, has rejected a commission record because it contains information that was in violation of Rule 138. And now the chairman has instructed the arbitrators and commissioners to not even accept as exhibits, right, any documents that are in violation of Rule 138. So once again, just to review what is prohibited by Rule 138, Social Security and individual taxpayer identification numbers. I expect that that's on a lot of different kinds of documents that we admit into evidence, right? Medical records, for sure, sometimes contain the Social Security number. Bills might sometimes contain the Social Security number. I'm sure there are a bunch of other examples you can think of common exhibits that we might put into evidence that would contain Social Security numbers. It's going to be the party's responsibility, and I suppose it's the party that's proffering the exhibit, to redact the prohibited information before that exhibit would become admissible. Okay? Driver's license numbers. I'm not sure that I can think of an exhibit, common kind of exhibit off the top of my head that would include that, but some people have told me some medical records actually. So what's being brought up is sometimes in the I&E reports, there's a photograph of the driver's license. In some of the, bill kind of things, that a hospital might take, like an admission record, and sometimes make a copy of the driver's license. Or it might be included on some other kind of bill or something like that. A police report, okay? So we're coming up with a lot of different examples where there might be prohibited information, 138. Financial account numbers. I think what this means is like bank account numbers, right? I suppose this might come up in an average wage case, right? Where you're trying to figure out what the average weekly wage is, how much were deposits made to a particular bank account, checks that were given to the petitioner, those have financial account information on them. So that's where that might come up. Debit and credit card information, I'm not sure, again, that I can think of a quick example of that, but I suppose maybe if a petitioner paid a medical bill with a credit card and is seeking reimbursement for that, there might be some credit card information on something like that, okay? So from here on out, we've been duly warned, right, that if you show up with an exhibit that has some information that is prohibited by Supreme Court Rule 138, the arbitrators and commissioners have been instructed to not accept that exhibit until the proper redactions are made. All right? Any questions? Yes, sir.
I was assuming that would not
So the question is, does number 3, financial account numbers, include the bill numbers on a bill? I don't know. I don't know the answer to that question. Anybody got any ideas about that? Maybe better safe than sorry, but I think that might, just think off the top of my head, might you not run into some problems from a petitioner's point of view with your opponent, right? Where you say, here's a bill, and you've stricken off the social security number, and you've stricken off the account number, and you've stricken off everything else, and your opponent says, who's this for? How do I know that this is for your client? So apparently Rule 138's been around for a while, and I got to admit to you that I was never concerned about it, but as of July 24th, 2019, we've been advised, so start getting concerned about it if you haven't been concerned about it already. All right, anything else? Any other questions, concerns, comments? Okay, good. All right, well then let's start our discussion about the Benson case. So, again, in the appellate court, Benson ends up being a Rule 23 case, but it's a really interesting case because I think it illustrates some of the issues that we've been talking about here and maybe even ad nauseum talking about here in the last few programs. But I think it just shows that the commission, the arbitrators, even the appellate court, and certainly us lawyers, that we are struggling with this idea of what does arising out of mean, what are the nature of these 3 kinds of risks that we seem to be talking about every month now, personal risk, employment risk, neutral risk. So it's a case that grabbed my attention because when I saw it reported, even though it was Rule 23, it seemed to be right on point with some of the issues we've been talking about here, including that McAllister case that we talked about a couple of months ago, which talked about this idea of everyday common activities and how an everyday common activity can be compensable or not compensable under the Act. So I just want to take a second to give you the setup on Benson by reading the statement of facts from the appellate court, because it's a pretty interesting statement of facts. It's in your written materials there, so if you want to follow along, you can. The claimant was employed by Kirby, which is Kirby Medical Center, as a janitor. His duties included transporting linens to off-site locations. He was assigned to transport linens via a company truck to a different location. The truck was parked by a ramp-like loading dock, which had stairs at one end and a wheelchair ramp on the other side, and a hydraulic lift used for the movement of freight. So the way I envision this is that there's this hydraulic lift that's built into the loading dock, and you're going to see why this hydraulic lift becomes important in the commission decision in just a minute. The petitioner testified that when he discovered that the company truck was low on fuel, he went to the office of his supervisor to obtain a company credit card to purchase gas for the vehicle. The supervisor's office was located right next to the loading dock. The supervisor gave him a credit card and said, go fill up the truck with gas so that you can make these deliveries and bring the receipt back to me. But hurry up because I'm about to leave work for the day and I want the receipt before I leave. So he leaves the supervisor's office, the petitioner leaves the supervisor's office right out onto the loading dock, but rather than using those stairs or that ramp, he decides, and it's described as purposefully decides, to jump off the loading dock. When he did so, his right foot and leg struck the hydraulic lift and he fell to the ground, inverting his left foot, resulting in a fracture of the foot. The petitioner testified that jumping off the loading dock was his routine way of exiting the dock, and that he jumped off of the dock 3 to 4 times every day. And according to the petitioner, the supervisor and one other supervisor had seen him jump from the dock on some number of occasions and had never told him, hey, don't do that. The supervisor denied that she ever saw him jump off the dock. The petitioner admitted that no one ever told him to jump off the dock to reach the ground level, and there was actually a surveillance video of this whole accident. So, I mean, it showed him jumping off the dock, it showed him catching his foot on the hydraulic lift, his right foot and leg on the hydraulic lift, and then he fell to the ground below the dock. Okay? So those are the facts, right? So here's what the arbitrator decided, and here's how the arbitrator thought that some of those facts that we just talked about were important. Okay? Again, there was this surveillance video that showed the whole thing, right? So this was not an unwitnessed accident. I mean, the camera witnessed this accident, so there was no inferences to be drawn about exactly how this happened or anything else, right? I mean, it was what it was. It was on tape, so to speak. Again, the petitioner himself testified that he purposefully jumped from the loading dock. So that was not an issue. Right? What was not an issue in this case was, did he fall off the dock? Did he not know that he was near the edge of the dock or whatever? He intended to jump off the dock to get to the truck. It was purposeful on his part. He thought he was doing that because it was a quicker way for him to get down to the ground, and he was actually asked about that, right? How long would it have taken you to take those stairs on the one end? And he said that would have taken me about 30 seconds long, okay? And he was asked, how long would it have taken you to take that ramp on the other side? And he said that would have taken me about 60 seconds longer to do it that way. He agreed that he was never told, verbally or in writing, by the employer to ever jump from the loading dock. So he was never told to jump from the loading dock. But in addition to that, and I think it's in this record somewhere, although I wasn't able to pull it out, I don't think he was ever given like a written rule or told, don't jump off the dock, right? Rule number 1, don't ever jump off the dock, right? I'm not sure at the end of the day that would have mattered anyway, but I couldn't necessarily find any specific reference to that in the decision itself. The job description doesn't say, part of your job description is jumping off the loading dock, right? Of course it doesn't say that. It says drive the truck to get gas, drive the truck to drop off the linen, and observe all safety protocols, right? So not necessarily specified, but be safe at work. That's rule number 1. Be safe at work, right? So let's look at how the arbitrator decided the case. Okay? So what the arbitrator says is that it is clear and the word clear is used, it is clear from the surveillance video that petitioner's actions took him entirely out of the scope of his employment, and he was injured while violating a common sense safety rule. The arbitrator uses the word clear. The arbitrator says that it took him entirely out of the scope of his employment. The arbitrator said that the petitioner voluntarily did this, which the petitioner admitted. I purposely jumped off the dock. It was a voluntary action. It wasn't like a twitch or something like that. I purposely jumped off the dock without the knowledge of the respondent to engage in a hazardous method of taking himself off the loading dock when his duties required him to make the trip in a safer manner. Okay? The arbitrator goes on to discuss some of these alternative route cases, right? Everybody knows what I'm talking about, I think, right? So there's a case called Hatfield, right, where a petitioner decides that instead of walking around the ditch in the company parking lot, he's going to jump over the ditch, right? And the appellate court in that case says that that's not compensable because he chose to jump over the ditch rather than walk around the ditch. The arbitrator refers to a case called Dotson, D-O-D-S-O-N, and this was the one where the petitioner, instead of taking the sidewalk, decided that she was going to go up the grassy knoll, whatever it was, right? The slippery, grassy, what do they call it? They don't call it knoll, slope. The slippery, grassy slope, and she slips in the grass, and the appellate court says that's not compensable either, right? So you can see where the arbitrator's going with this, right? If kind of this idea, if there's a safer route that you should have taken, you should have taken the safer route. It's not, it's not the liability of the respondent if you, as a petitioner, choose a safer route. The arbitrator decides that the injury was not the result of fulfilling any duties required of his employment, and thus there was no employer-employee relationship at the time of the accident. So look how far the arbitrator takes this, right? Because the petitioner jumps off the dock, the arbitrator says he's no longer an employee. At the moment that he jumps off the dock, he was not fulfilling any duties that were required of him, and the arbitrator says that that act is so extreme that he's no longer an employee at the time that he jumps off the dock. The arbitrator talks about the personal employment neutral risk analysis, which we're going to talk about more when we get into the commission decision and the appellate court decision. And here's the wrap-up from the arbitrator, okay? Here's the wrap-up. When petitioner ventures from a safe route provided by the employer for ingress or egress, and instead purposefully jumps from a loading dock onto a hydraulic lift, thus falling off to the ground, he has exposed himself to an unnecessary personal risk for his own personal convenience. Therefore, any injury sustained while performing this activity is not within the employment relationship, we talked about that already, and does not arise out of or in the course of the employment. So it's the triple play, right? It's a triple play. You're not an employee, you're not in the course of, doesn't arise out of when you jump off of a dock. Okay? So let's take a little minute here to discuss the arbitrator's decision. So what is the arbitrator's decision here? We know about the employment relationship, and we're going to see that gets overturned here in just a second. And we know about the in the course of, we're going to see that gets overturned here in just a second. But how do you think the arbitrator is analyzing the arising out of here? Yes, Dave.
So, in the arbitrator's opinion, let's say that dock was defective. And yeah, there's a whole lot of contributory problems on the plaintiff's part. But the arbitrator is basically saying that the plaintiff, that the worker can now sue the employer, because the arbitrator is taking him outside of his employment. My question is, why can the arbitrator use a horseplay analysis? I'm not talking about the decision, I'm talking about the analysis.
Well, so the question is, and it's a really good issue, right? This idea of purposefully taking an action, right? Right? If you purposefully take an action that is horseplay, all right, we all know that that means that it's not compensable, right? We all know that horseplay is not compensable. If you're asking me, and I'll open it up to the crowd here in just a second, but if you're asking me why didn't the arbitrator analyze it that way, I don't think there was any evidence that it was horseplay. This guy said, I was trying to get to the truck in the quickest way that I knew how, and that's jumping off the dock, which I do 3 or 4 times a day. No big deal, right? I don't think there was any, it wasn't like, somebody said, one of his pals said, go deep, and he ran and jumped off the dock, right, to catch a football or something like that. It wasn't like that at all. He was intending to get to the truck so he could drive it to the gas station, fill it up, get back, hand his supervisor the receipt before the supervisor left for the day. I don't think there was any evidence that it was horseplay, right? Anybody have a different?
I think the real problem is he plays for his own personal convenience. He wasn't doing this for his own personal. He was doing it because the supervisor said,
okay, so the point is, what about this phrase, own personal convenience, right? So there's an argument, one might suggest, to be made that it wasn't for his own personal convenience, right? He wasn't like the guy in the case called Orsini, right, where he's fixing his own car, right, at the garage, right? He wasn't going to his own truck to fill up his own truck with gas, right? He was going to the company truck to fill the company truck up with gas so that he could make the delivery that he was required to make. So there's an argument to be made that it wasn't for his own personal convenience. But there might be an argument to be made that, so what if it was his own personal convenience? When I hear personal convenience, it kind of reminds me of something called the personal comfort doctrine, right? And we all know that personal comfort is compensable, right? Things done in pursuance of personal convenience, comfort, are compensable, right? Any debate about that? Mark, I always can rely on you for debates.
Yeah. There's no question that he's trying to do something in furtherance of his employer's interests. He's trying to save 30 seconds or so, but that has to be placed up against the danger, so-called, that he placed himself. That's where the contest comes in, and that's why we have the debate over whether this is not a work-related risk.
So Mark, I don't need to put words in your mouth, but Mark suggests kind of balancing tests, right? How extreme was the action compared to what the petitioner was trying to accomplish, or something like that, right? A balancing test. So anybody want to argue with the balancing test? Yes, Matt, please do.
So the problem with arguing with the balancing test, and the same thing that comes up whenever you say someone violated a safety rule, is who does the benefit eschew to? So it isn't a personal convenience. The benefit goes back to the employer, and therefore it should be that. If that's the analysis, this should be compensable. I'm not saying this case should be compensable, but if you're going to do a balancing test and say somebody violated a safety rule, you have to identify to whose benefit it ultimately goes to.
So the question is, if you're going to do this balancing test, right, or maybe not, if it has to do with the violation of a safety rule, and by the way, at the end of the day, you're going to see, I'm not sure this case involves a violation of a safety rule. I think you're going to see that maybe as we go along. But if you're going to do that violation of the safety rule analysis, you still have to do the analysis of, was the petitioner still engaging in something that was to the benefit of the employed, right? And we're going to see a case here that is kind of off topic in just a second, where you know, what some people might actually call a super outrageous act by the petitioner was actually deemed to be compensable. And Mr. Schramm, at that point, I'm going to call on you to talk about that case. So
It's an amazing case.
yes. So,
And
all right, Mark, can I move on? Just let's check up, okay? All right. So let's talk about what happens. Of course, the petitioner files a review to the commission. Let's talk about how the commission analyzes the case compared to how the arbitrator analyzes the case. So the first thing that the commission does is to reject this idea that there are acts that actually take a petitioner outside of the employment relationship and, you know, render him no longer an employee. So the commission says that the commission finds the petitioner did establish an employee-employer relationship at the time of the injury. The commission does not disturb the arbitrator's ultimate determination, however, because the commission finds that it did not arise out of the employment. Okay? So regarding the arbitrator's finding that there was no employer-employee relationship, the commission doesn't take, and they call it such a draconian view as the arbitrator did. The case precedent finds that for conduct to produce severance from employment, such conduct must be egregious, reckless, or completely unrelated to the claimant's employment. Mere negligence or violation of the safety rule, maybe this balancing act that we've been talking about, will not, in and of itself, suffice to sever an employee from the employment risk when an employee's actions were otherwise aimed at the furtherance of his employment duties. So what Matt talked about, right? Aimed at the furtherance of the employment duties, excuse me. Okay? Nevertheless, the commission says this is not a compensable case because while the injury occurred in the course of the employment, so again, the commission rejects the arbitrator's conclusion that it did not occur in the course of the employment, the commission says it did not arise out of the employment. Let's take a look at how the commission comes to that conclusion. Petitioner's preferred route off this particular dock was not especially risky. So the commission says, look, this it's not that tall a dock. It's, you know, a pretty short dock as docks go, you know. It was free of any debris. There was no premises defect. But don't forget, the petitioner said, I struck my foot on the hydraulic lift, right? So maybe not defect, but he certainly said, you know, there was a lip on this hydraulic lift, and I struck my foot on the lift, and that's what caused me, as I was jumping off the dock, instead of landing, you know, with a perfect 10, like Nadia Comaneci, right? I broke my foot instead, right? Because I struck my foot on that hydraulic lift. So I'm not sure this isn't necessarily about the employer's premises because of that hydraulic lift being there, but be that as it may, the commission says this wasn't an especially risky kind of thing that the petitioner did considering what this dock was like. While the parties may assume reasonably that the stairs would have been a less risky route than the non-stairs option, I love that, right? The non-stairs option, right, selected by the petitioner, the proposition that the petitioner's chosen route was inherently dangerous is not warranted, all right? So the commission is rejecting this idea of the safer route analysis, right? Just because there was a safer route doesn't mean that the route that the petitioner took is not compensable, right? But the reality is that the petitioner's fall did not stem from any dangerous condition of the employment. What about the hydraulic lift that he tripped over, be that as it may, or work-related increased risk of harm, okay? But from a fluke, and this is a direct quote from the commission, it resulted from a fluke, right? What? Is there a synonym that anybody can come up with fluke? For fluke, is there a synonym that anybody can come up with? Accidental, maybe, like accidental injuries, okay? Again, be that as it may, this is the commission's reasoning about why this case is not compensable. So, what analysis is the commission applying to this case? Is it applying a personal risk analysis, right? I don't think so, right? That's not especially risky, that's not, taking a safer route, right? They seem to reject the personal risk analysis, right? What about the employment risk analysis? Are they using an employment risk analysis? I think they pretty clearly tell us did not stem from any dangerous condition of the employment, okay? So I think they're rejecting the employment risk analysis, which only leaves us with one analysis left, right? What is it, everybody?
Neutral.
Neutral risk, right? So, as far as I can tell, the commission has applied a neutral risk analysis to deny the benefits in this case, and they say that's because of this fluke, right? This is not the kind of neutral risk that we've talked about here that can turn into an employment risk because it was a fluke, right? It was a fluke. It may never happen again. Yes?
So if he took the stairs the way everybody wanted to, he tripped over his own feet, that would be a fluke, just like this. Unfortunately, the commission, sorry, commissioners, neglected the fact that the guy was on a mission. He's in a hurry. So the title of the today, it has nothing to do with the fact that is jumping off the loading dock compensable. The commissioners already told us, yeah, it's no big deal. It's not especially risky. The problem is they forgot that this guy was told he's got to get back with that credit card. They forgot about that.
So I think Dave's onto something here, right? Because if you look at this last sentence, right, they say, as the petitioner testified, he just took a misstep. My foot slipped out from under me, right? So at the end of the day, maybe what we have here is an unexplained fault, right? Maybe this is an unexplained fault. I don't really know what happened, except that everybody saw what happened because it was on videotape. His foot hit the lip of that hydraulic lift, which, even though he was in the process of jumping, caused him to lose his balance and not come down with a perfect 10, right? And that's the problem, in my opinion, with this analysis. My foot slipped out from under me. No, it didn't. We saw what happened. Your foot hit that hydraulic lift, which is what caused you to not land it perfectly. All right? So, Mark, you had a point.
No, it's just bad preparation. I agree with you. He tripped over the hydraulic lift. But to follow up on David, the same argument could be made if he's driving 50 in a 30-mile-an-hour zone, that he's in a hurry, he's on a mission. So let's not go down that rabbit hole. We're already on the rabbit hole with the neutral risk thing.
But Mark, you know us. We love rabbit holes. So let's talk about the rabbit hole. So are you suggesting that a trucker who's driving 60 miles an hour in a 55-mile-an-hour zone, right, that when he hits the patch of black ice or whatever it is and drives off the road, that's not a compensable incident because he's driving 60 instead of 55 or driving too fast for conditions?
First of all, he's traveling, so that.
Okay.
But all I'm saying is that if you're exposing yourself to risks that you shouldn't be taking merely because you're on a mission and you're in a hurry, that's not a very good explanation for trying to make the case compensable. Better, the thing that you and I agree with is that he just didn't testify appropriately. I'm not getting down on the lawyer. He tripped on the hydraulic lift. So I'm the arbitrator. I'm hearing these facts. Yes, he was told not to jump off that. So that has to be balanced against the fact that he was doing work. In the meantime, he tripped on this lift. So you have to balance all of those facts. I don't know if they came to the right conclusion. I might have come to another. But this being in a hurry, that cannot justify all sorts of actions.
But up until now, it has, right? I mean, we've talked about, falling downstairs, right? And we've talked about this idea that if you're carrying something, right, which is what, Knox County or something, right? That's that case. Or if you're hurrying, which is Is it FedEx, what?
Seeds.
Seats, right, seats, right? So this idea of carrying or hurrying something, hurrying, right? Even if you can't identify what made you trip, if you're carrying or hurrying, right? That's a compensable thing. Now is hurrying such an extreme act that it doesn't arise out of anymore. So think the exact thing that we used to think made it compensable is now making it not
Well,
compensable.
we're balancing, he was told not to jump off the dock.
No, he wasn't.
Okay, but,
The supervisor testified.
okay, let's talk about that issue because, so this is a great,
The commission said it was risky, they had ACL, but they took us out of it. They said it's not especially risky.
so this is,
So now it's a slip, so Dave, let's have him get to his car, he didn't get hurt. And he comes to a stoplight, and my foot slipped, I fell off the brake. That case is not compensable, according to this cockamamie decision.
There's a term.
all right.
Yeah, I don't think
Well, so, let's talk, I mean, a couple of issues have come up, right? Traveling employees, right? We talked about traveling employees. What, do we recall what this guy's job duties were, right? Taking things to different locations of this medical center, right? Was he a traveling employee, right? And remember last week, or last month, why time flies, man, last month, we talked about a case where it said, you're a traveling employee even when you're on your employer's premises, right? If you're a traveling employee, it doesn't matter that you're on your employer's premises. That doesn't mean you're no longer a traveling employee. You're a traveling employee even when you're on your employer's premises, right? So was there a traveling employee analysis to be made here? If there was, it was. I don't think it was made from what I can tell. Okay? All right. Yes, ma'am.
But it's not reasonably foreseeable to do that, and then it wouldn't be compensable.
So Matt is suggesting that in anticipation of what we're going to hear from the appellate court here in just a few seconds, right, that it isn't reasonably foreseeable that a guy's going to jump off a dock. Okay? Matt, I think I can argue with you about that, right? I've had the great fortune in my life to only have to work in a factory for a few years, right? But guys were jumping off docks all the effing time, right? Not engaging in horseplay, not that's the way workers get off docks in a lot of the time, right? I would strongly disagree that it is not reasonably foreseeable to an employer that its employees are going to jump off docks to perform their job. Okay, I think there's an argument to be made. All right. Okay, so let's move on. So the circuit court confirms, right? But before we talk about the appellate court decision in Benson, I wanted to talk about this really interesting Hines interest case, right? Because I thought, well, if the idea here is that this jumping off the dock was such an extraordinary, extreme act, right? What other cases have there been where a petitioner is engaged in an extraordinary, extreme act, right, but still received benefits, right? Just to kind of give us a compare and contrast kind of thing. And I didn't come up with this case on my own. The petitioner's lawyer, when he argued the Benson case in the appellate court, this is the first case that he cited, Hines interests, right? And he did what Justice Holdridge has told us in some of the meetings that we've had with him, right? The luncheons that we've had with the appellate court. Like, lead with your strongest case first, right? And so the petitioner's lawyer in this case says, I'm leading with my strongest case first when I make this argument, and here's my strongest case, Hines interest. So, Neil, you may remember this case, right? Because this was Mr. Schramm's case, right? And correct me if I'm wrong about any of these facts. So, here's the facts. The guy, the worker, I shouldn't say guy, the worker has a great performance review with his boss. Right? For the first time in like 5 years. The boss has been all over him for 5 years. You're worthless, you're horrible, you're bad. And he walks out of his first great performance review in 5 years. As he's walking down the hallway to get to the basement where he has to go to turn on the air conditioning or heating or whatever it was, right? He's a stationary engineer. He says, oh, I forgot the keys. I locked the keys in the basement. What do I do now? I don't want to walk back into the office and tell my boss who just gave me my best performance review I locked the keys in the basement. We're going to have to break the glass to get the extra keys. But we're going to have to we get a locksmith to come and unlock the door. So I got an idea. I'm going to get the janitor to come and give me a hoist, so to speak, down into the basement. So our hero decides that what he's going to do is hook up a mop bucket to a chain on this hoist, stand in the mop bucket, and have the janitor, who I'm gonna elaborate just because I can, the Polish janitor who can't speak English, and have the guy lower him through a manhole cover in the floor, lower him 30 feet down into the basement. Well, you can imagine what happens, right? He gets 5 feet down, the hoist locks up. He's yelling up to the Polish janitor, help me, and the Polish janitor's like, no, speak English. I don't know what to do now. Everybody comes to his rescue. They're trying to pull the chain up, and the bottom drops out of the bucket. 20 feet to the floor, bam, he's out like a light. Well, the keys are locked in the basement. So they got him, they're yelling down to the guy, they finally wake him up. He crawls to the door, apparently, unlocks the door, the paramedics rush in and rush him up to the hospital. So I'm sure it was not as fun an experience for him as it is for us today, but that's the story. Guess what? Guess what? Compensable case, right? Compensable case all the way up. Why? The appellate court says, yeah, he did something really stupid, but he was trying to do his job, right? He was trying to do his job, even though it was really stupid, right? So that's the case that I came up with when I was trying to do the compare and contrast. Anybody else want to talk about a case they know about? Yes, sir.
Well, no, I was just going to say, I think it's because Neil called it the non-ladder option.
Right. Yeah, this was certainly the non-ladder option. Right? This was certainly the non-fixed extra set of keys option, right? Right. So.
They didn't have neutral risk then either.
Yeah. And Mark says there was no neutral risk.
That's when common sense prevailed back in the day.
Yes.
If this guy had fallen by himself in today's
Defense.
right, it would be comparable to the case we're studying now. But I think that here too, you can say, his accident came because of the people helping him or breaking or whatnot, defect in part, no works. I think if you just shimmied himself down, they may have said it was ultra dangerous.
All right. So there's a distinction, yes.
He did shimmy himself down really, and his clothes got caught in the line. And when I
Oh, that makes it a lot better.
when I signed up this case, I almost fell to the floor of laughter, passing my client, because it's the stupidest and funniest for the thing. But here's one factor out of that case that maybe, and I don't think it's necessarily mentioned in the appellate court decision, it's been a long time, but inherent in what he was doing was within the sphere of his employment, and getting down there in a timely fashion was so important to the building management company, because turning off the coolers, it was a 5 o'clock turn off, was an expensive proposition if you didn't do it in a timely way. So the money issue enhanced the benefit to the employer to make it more compelling. But truthfully, I don't know what happened. This is nothing compared to mine. And this one was denied. I think this one's ridiculous.
Look at the people.
Let's take a quick look before we have to end about what the appellate court decided in the Rule 23 about the Benson case. So, first of all, the appellate court tells us, even though we've got the accident on film, right? This is one of those on-film accidents. Even though we've got the accident on film, because different inferences can be drawn from looking at the film, all right? It's not a de novo question of law case, it's a manifest weight case. So it's a manifest weight case, is what the appellate court tells us, and that's what I'm going to tell any respondent lawyer who says jumping off the dock is not compensable. I'm going to say that's a manifest weight case, and it's on the facts of that particular case. But in any event, the appellate court tells us that they're using the manifest weight of the evidence. They summarize the two parties' different arguments. So they say, here's what the petitioner argued, right? The petitioner argued that he was required to get down from the loading dock, right? And however he did it, doesn't matter, right? Violation of the safety rule, taking a risk, not taking the safer route. He was required to get down off that dock in order to complete his job, and therefore it's an employment risk, right? It's a risk associated, incidental to his employment. Getting down off of a dock, however you choose to do it, is a risk incidental to the employment because you got to get off the dock in order to drive the truck. The respondent says, no way, right? Jumping off the dock is not incidental to the employment, right? So they define the action as jumping off the dock, not getting down off the dock, right? And he voluntarily did this. This was something he chose to do. It was unnecessary. He didn't need to do it. Therefore, it's a personal risk, or it's so outrageous that it takes him out of the scope of his employment and he's no longer in the course of the employment. So that's the respondent's argument in the case. So at the very outset, the commission rejects this idea of in the course of, the appellate court rejects this idea of in the course of. The appellate court says, of course he's in the course of his employment, right? He's trying to get to the truck, he's on his employer's premises, it's during the period of time that he's supposed to be working, he's at least ostensibly engaged in something that his employer requires him to do. Of course he's in the course of his employment. So what are we left with? Arising out of, right? And the appellate court once again reminds us, as it's been doing very frequently lately, that you've got to do this risk analysis. When you're talking about the arising out of prong, the first thing you should think about as lawyers and judges and arbitrators and commissioners is, what is the risk analysis? The three different kinds of risk: personal, employment, neutral risk. Okay? What does the appellate court say about personal risk? The appellate court says this is not a personal risk. There is no evidence that his injury was the result of a personal risk, such as an idiopathic fall, right? He didn't faint and fall off the dock, although, right, there's that line of cases that say if you faint from a height, the risk is the height, not the fainting, right? Be that as it may, they say this is not a personal risk. But I think that also means it's not a personal risk that he decided to jump off the dock, right? That he voluntarily chose to jump off the dock doesn't make it a personal risk. It's not an employment risk, right? The appellate court says this is not an employment risk. Nor is there any evidence that the risk of injury from descending from an elevated platform to the ground level was peculiar to the claimant's work, or that the risk was the result of a defect in Kirby's premises. Okay? Maybe not defect, but that lip of that hydraulic lift had something to do with him falling, right? Everybody agreed that it did. Why are we talking about the hydraulic lift unless the hydraulic lift had something to do with it, right? There's a case out there called University of Illinois. The petitioner's name is Nadine Burns, and she trips over a perfectly non-defective threshold, right? Doesn't have to be defective, right? We talked about the Tinley Park case, right? Where it, right, Rich, it's perfectly new carpet, right? Doesn't have to be defective, right? So, in any event, the appellate court says, no way, this is not an employment risk case. Instead, it's a neutral risk case. It's a neutral risk case. And the appellate court says, members of the general public encounter the risk of injury as they descend from elevated platforms or structures to the ground level in their everyday living. Okay? So, that's what the appellate court says. It's not a neutral risk that is a kind of neutral risk that is compensable because members of the general public descend from elevated platforms or structures to the ground level in their everyday living. Okay? I have not descended from a dock for many years now. Okay, I don't know how many of you have descended from a dock in the last week, or month, or year, or 10 years. I would presume not a whole heck of a lot of you, okay? So I don't necessarily know that it's a truism that members of the general public encounter the risk of injury as they descend from elevated platforms to the ground level in their everyday living. I just don't know that that's an always true statement. Yes?
Dave, don't you think stairs are an elevated platform? Your
Yes.
deck is an elevated platform.
Yes.
If they had said everybody descends from a dock in a regular course of their regular day, I would see your point.
So Steve brings up this idea, isn't a dock kind of like stairs, right? It's a way of descent.
No.
Okay.
It's an elevated.
Okay, then let's,
When the appellate court says stepping down from an elevated platform is an everyday act by the general public,
and the appellate court has said that about stairs too, right? Remember, the appellate court says stairs in and of themselves, right, are not the kind of neutral risk that is compensable unless you do the qualitative or quantitative analysis, right? Villa Park case, right, which we talked about last month, right? It's not the stairs that is the risk, it's the frequency with which you go up and down the stairs. The quantitative analysis that turns a neutral risk into an employment risk, right? Do you remember way back when we started this an hour ago? How many times did Benson say he had to get down from the dock in the course of the day?
3 or 4.
3 or 4 times. Remember what we talked about last month? How many times did the guy in Villa Park go up and down the stairs? 6. Right? Was it 6? 12? Was it 12? Was it 12 up and down or 6 round trips?
3 up and down.
I think it was 3 up and down. I read the site from Villa Park here last month, and I think it's subject to some interpretation. But there's one interpretation that says it's 3 round trips, right? So, which would be 6 or something, 6 up and down or 3 round trips or whatever you want to call it, right? If this guy is descending 3 times, then if my math is right, he's got to be ascending twice, or is it 4? Twice, right? Or 3, I don't know, whatever, right? He's ascending this, right? Right. So the appellate court says this is not a neutral risk, but they don't talk about the Hines interest case. They don't talk about any of those kinds of cases. They don't talk about the qualitative, quantitative analysis, right? They just say because the general public does not encounters elevated platforms or structures, this is not the kind of neutral risk that is compensable. Okay, so anybody want to wrap it up? Yeah.
I thought in 1912, the legislature the workers' contract created a no-fault system. And that seems to be what we're doing. Other cases we were talking about, using all these
I don't know, maybe we can do a program on it next month. Yes, sir.
Do you think if the commission has ruled in favor of the petition, there's no further affirm that?
Absolutely.
Well, they said it's a manifest weight case, right? So again, when they say it's manifest weight, I always say, well, that's the facts of this particular case. So, yeah, I think, right, as we all know, as we experienced practitioners know, right, the ball means at the commission, right? You bet, if you have a hope in, if you have a hope, you better prevail. Rich Alexi's the only guy I know who routinely gets them to flip on manifest, to flip on manifest weight, so.
That's because Benny Nell is such a nice guy.
All right, anything else? All right, thanks, everybody. Thank you.